Welcome to the Legacy Leaders Podcast. Are you doing the best for your client to help them create their legacy? Are you creating a plan that goes far beyond finances to help people ensure that it becomes the driving force behind all decisions? On this podcast, hosts Beth and Stan Miller will help you with growing your practice and your client's peace of mind. Together, they bring the best and brightest minds to share with you how to help your clients develop their best legacy. And now, here are your hosts, Beth and Stan.
Welcome to the Legacy Leaders Podcast. I'm your host, Stephen Stepp, and today my guest is Kern Singh, who is the founder and president of the Singh Law Firm, with offices in both Northern California and here in Southern California as well. And Vern, thank you so much for joining me today.
I appreciate it, Stephen. Thank you so much for having me on the show. And thank you to all the listeners joining as well. I hope I'm able to bring some knowledge to everybody today.
Oh, I'm sure you will. I'm sure you will. To get started, I want to find out why law and why estate law in particular. What drove you to this field in general and to estate planning in particular?
Wonderful. Thank you so much, Stephen. It's a question that takes me all the way back to elementary and just upbringing in my household. My dad was a doctor. He had his own medical practice. And so I saw him. And then growing up, especially in an immigrant family, typically they want you to become a doctor and engineer. And my dad discouraged me from becoming a doctor just because of the politics he was seeing. And so I liked the area of law. I think the big thing for me when I decided that law school was for me was, I believe, in middle school, about 7th grade, when I got into watching The Godfather. And I realized that I'm not of Italian descent. I'm not going to be able to join these guys. So maybe I can become a lawyer for these guys. And all jokes aside, I was the Tom Hagen. And for me, going into law that was the precursor, but also at the same time, it was an accepted area of as far as a profession for my folks. But I enjoyed it thoroughly. I actually worked full time when I was 16 during one of my summers with a local law firm growing up. And that's when I truly fell in love with just the general practice of law. Now, the area of laws that I've practiced in the past were construction litigation, a little bit of family law, criminal prosecution. I was a DA in San Francisco for a little bit. And my idea was that ultimately, I was going to go out and practice on my own, and I was going to start a criminal defense practice. So I went to work for the DAs, got a bunch of trial experience in hopes that I would transition over into private practice in criminal defense. My wife, who happens to be an attorney, also a partner in our firm, was already doing estate planning, trusts, and estates. And I realized that doing litigation wasn't going to be well for my family just because of the amount of time it was going to take after hours and on the weekends. So to have a good family life balance, I found that trust and estates was great from a transactional standpoint. It allowed me to have a great balance. But I also am a businessman at heart at the end of the day. That's truly who I am. And I feel like numbers and working with families and helping them parse through just the asset distribution and protecting their families from a legacy standpoint was very fulfilling. It solved that issue of business for me as well, just because I'm very well versed in it. So the transactional aspect of it just worked out really well for me. So that's kind of where it goes from how did I decide to go to law school and how did I decide the path of becoming a lawyer as well.
Got it. And how did it come about where you founded your own firm?
Yeah, so it was just that I wasn't going to go work for anyone else. That was what I had told myself. I wasn't going to go work for anybody else. I needed to go start my own business. And so it's funny, sitting in the back of my law school, and I told my deans this when I graduated and passed the bar. I went back to my deans and said, hey, look, sitting in the back of your class or classes, I was designing our letterhead. I was designing my business card. My first year of law school, I had already purchased our domain name. So for me, it was already a vision that I had. I already knew what I was going to do. That was the route I was going to take. And that's just it. That's what we were going to do.
Awesome. So you not only decided early what you wanted to do, but that you were going to do it on your own terms with your own business.
Set that vision, set your goals, and start to plan what you're going to do today, tomorrow to get to those goals. Yep.
Yep. I think that's awesome. And I think most successful people have the same thing. It doesn't just happen. They have to lay it out and plan on it and account for it and have that as their focus, right? So when there are bumps in the road, they're able to see past that and not get detoured and stay on track. That's awesome. And so in the planning that you have now, and you are totally only estate planning attorneys, right? So that's awesome, especially for our listeners. So what would you say is your ideal client?
Our ideal client is someone who's kind, happy, They're wanting to work with people and they're going to be respectful of my team. But more importantly, if you want to get down to the nitty-gritty, when you're looking at setting up an estate plan in California, most California residents, we have a probate process. And if you own any real estate or if you have any bank accounts or if you have minor children, these are three real big criteria that I said, hey, look, these are the light bulbs that should trigger. I need to take action for my family. I probably need to establish an estate plan for my family. And that would be essentially be our ideal client from a benchmark standpoint, meeting those three criteria, and then also making sure that, hey, look, this individual is kind, they want to work with my team. My team is there to help you and serve the clients. So we just want to make sure that we have a great relationship moving forward as well.
Awesome. And how can the ideal clients best find you? Just by going to the website or calling
Yeah,
or is that the best way?
Yeah, best way would be calling our headquarter number, which is 510-742-9500, or our SoCal office as well. And all those numbers are visible on our website, which is singlawfirm.com. So you can contact us via phone, email us through a contact inquiry on our website as well. You can also Google search us via the Singh Law Firm, and then just do some research on our website, take a look at our Google reviews, etc., and kind of just get some background on us in general as a firm overall.
Got it. Excellent. And another question comes up a lot of times with our clients and people and listeners are, what do you think are some of the common misconceptions that clients and when people first come to see you that they have in their mind that you're often having to correct?
That question is such an open-ended question, Stephen, that we could literally spend 2 hours going over all the various misconceptions. There's so many. And the reason for that is sometimes there's some preconceived notions that clients have in their minds based on maybe history, maybe stuff they've read in newspapers, books, magazines, things they've seen on TV, dramas, or misguided information on the internet, right? The internet does not provide all the information within context. And so that creates a lot of confusion as well. I think the biggest misconception that people have is that, wait, you know what? I'm too young to establish my estate plan. Estate planning is for individuals who are older or who are ultra wealthy, and that is completely wrong. The bottom line here is that, look, if you're establishing an estate plan or you need to establish an estate plan in California, the main reason would be that you have real estate, bank accounts, or minor children, and you're trying to avoid probate, okay? And a lot of people think, well, I can avoid probate by maybe adding my children's names to my bank accounts or my real estate holdings. Well, first and foremost, whether you're 80 or 90 years old and now you want to establish your estate plan because you didn't want to set it up when you were younger, that individual's lucky to have made it that far along without anything happening in between where they may have needed to establish a trust to avoid probate. Because remember, the whole purpose of establishing these documents is to help us when we die. So if we're thinking that we're going to wait until we're older, then we create that risk for our family that there's that issue where we are unprotected, right? So some of those individuals are like, well, we'll wait till we're older, but in the interim, we'll go ahead and add our children's names to our bank accounts and our real estate holdings. The problem with that is, one, you, the parent, have given a gift to your children by adding their names to the bank accounts and your real estate holding. And now you're fighting the IRS against a gift tax because annually there's a limitation on how much we can gift. And now you're going to be gifting above and beyond that. Now you, the giver, are subject to a gift tax or a gift tax return filing, right? So that's an issue that most people don't even understand. Secondly, by adding your children's names to your bank accounts and real estate holdings, is that now you've subjected your assets, which your kids have no rights over today while you're alive, you subjected your assets to your children's liabilities. Now your kids go out and get into a car accident and there's a judgment against them because you added their name to your bank account and to your home, that their judgment creditor can satisfy that judgment by putting a lien on your real estate, by putting a lien on your bank account because your kids' names are on there. And so in the eyes of the law says that those assets are also your kids. So that judgment can be satisfied. So now you've subjected your assets to your children's liabilities and creditors. The other thing is if you add your children's names to the title of your home, what you're doing here is that not only, again, you gifted the asset, so now there's a gift tax problem. You've created an issue of liability for your kids' creditors. But secondly, your children, when you pass, they're going to get that home. The concern there then becomes is that they're not going to get a step up in the cost basis of that property. They inherit your cost basis. So now there's a big tax burden for the child in the back end as well. And that's what we call those actions that we talked about, adding the children's names to your bank accounts and real estate holdings, thinking that you're going to circumvent the probate process. We call that the poor man's will. You haven't thought about it. It's simple, it's free to do it that way, but you're exposing your family to all kinds of problems. And that is the worst thing you can possibly do by trying to cut corners here. So
Yeah.
again, yeah.
And I think history has to do with it also. I think that a number of years ago, 10 or 12 years ago, that's how I had it. And then it took a lawyer explaining to me, no, that's not what you want to do. It wasn't for the real estate, but it was for the bank account.
Yeah.
And I figured if something happened to me and my wife in a joint accident or something, at least they would have access to the cash. But the trusts are a much better way of handling that and also keeping it out of probate. And like you said, you might accidentally make a gift to them when you already made a gift to them. So now you're having to do the whole gift tax, filing, where that was one of the things you were trying to avoid to begin with.
Yeah.
So,
100%.
yeah, I think that's, for those of you listening, that's a really strong misconception. And I think it's still out there. And I think some people do look to circumvent the system that way, but it's not the way to go, as we both understand. So that's awesome.
And Stephen, if you don't mind, I'll add another misconception here too.
Sure.
Is that another big one too is that people think that they should go online and do their trust through some do-it-yourself or LegalZoom or some other kind of format where they're not utilizing legal expertise. That is the worst mistake you can make. You're trying to save dollars and cents here, but when really most people change their cell phones every couple of years and spend a couple of $1,000s on a cell phone when they don't need to, but they don't want to plan for their family's future. The couple of $1,000s of establishing your estate plan properly through an attorney who is, seasoned in the work that they're doing, will save the family hundreds of thousands of dollars in the back end in probate fees and potential estate taxes. So it's well worth spending the money today to get the work done. And I'm not saying you have to come to my firm. Go out and protect your family. Take that investment and spend it. We buy homes in great neighborhoods to send our kids in to great schools. We save money in a retirement account in hopes of having a nest egg when we retire. We buy life insurance in the event we pass to have a death benefit coming to our family. We're planning through all of this. But there's one thing that's guaranteed in our life is that we're all going to die. Why aren't we planning for this when the time is right?
Yeah, no, absolutely. I think that's also another great point. I'm curious with you and in particular in the firm itself, what do you think is your special sauce or your special talent individually that maybe would inspire a client to come and see and work with you as opposed to the next attorney?
Yeah, 100%. I appreciate the question. So one thing, our firm exclusively practices in estate planning. We don't practice any other area of law. All attorneys, all teammates, all paralegals, top to bottom, we are only estate planning. So now, if a client needs a legal service outside of that wheelhouse, we will not touch it. We will refer them out to a colleague of ours, but we want to make sure that the legal services we're providing to our clients are most effective and very niche in the area. So I would say our unique selling point here is that this is the only area of law we practice. So call us the neurologists or the cardiologists of estate planning.
Got it. You're the specialist for that. And if they need something else, you have plenty of other people that you can refer to. I think that's great also. And these days, more and more, I think the people that do specialize are providing the most service because they're the most on top of it. There isn't going to be a change in estate tax law that you guys aren't going to be on top of, where if you're an attorney doing 4 different things, it could easily get by you.
You're switching gears constantly, right? You're switching gears, you're slowing yourself down, you're driving the costs up for your client because you're constantly having to learn new law because you're trying to do family law, estate planning, maybe you're doing immigration, maybe you're doing personal injury all at the same time. How can you be an expert in all of those when all of those are so deep in depth with the actual legal, the legality behind all of those areas of law? I think it's just very, very important to go to someone who is just very niche in their area, who can provide you, cut right through the fat and get you the information. The other uniqueness of us is that since we do specifically practice estate planning, we've got everything from top to bottom very seamless. We make the client journey very, very easy. Now, I know a lot of firms out there will send the clients with a huge questionnaire, fill this 30-page questionnaire out with all kinds of information that's really irrelevant for establishing the estate plan. A lot of those questions that they're asking should probably be dissected with a client facing with the attorney or with the team interaction to get the information. But what we do is we make the process very simple, start to finish, very smooth. And so I think that's what our big thing is. We're very responsive and we're very quick to act.
Got it. And this because this has come up recently on a couple of occasions and with a couple of attorneys that I was aware of here in Southern California. Do you have a special process on helping clients make sure that once they do set up these trusts and other plans, that they actually put the assets into those particular trusts? And I'm only bringing it up because literally 2 weeks ago, I learned of it wasn't anything to do with me, but I learned of a case where somebody had 3 or 4 years ago, they thought they had done all this. They went and set up a trust, but the attorney had not been insistent on making sure or had a system to make sure that those had actually gotten in the trust. And then, of course, something unexpected happened, and it turned out everything had to be probated because almost nothing was in the trust. So I'm curious as to if your firm has any guideposts on making sure that once these trusts are set up, that they get properly funded.
Thank you, Stephen. So for all the listeners, what Stephen is addressing here is funding your trust. So simply establishing a trust, a revocable trust by itself is not going to necessarily help a family avoid probate. So you got to envision or imagine that it's similar to going on vacation. So if I was going to Hawaii on vacation, I throw my suitcase on my bed, I throw my board shorts, sunscreen, and flip-flops in my suitcase. And so when I got to Hawaii, my board shorts, sunscreen, my flip-flops were in my suitcase. But imagine me taking my suitcase the night before traveling, and I just made a list. On my list, I put down board shorts, sunscreen, and flip-flops, and I put that list in my suitcase, and I go to Hawaii. Open up my suitcase, and all I got is that list. It's useless to me. So your trust is very similar. Your trust has to have your board shorts, your sunscreen, and your flip-flops in there to help them protect, so that when that suitcase gets handed over to your trustee when you pass, your trustee actually has access to those assets, right? So what you really need to do, and we focus in on our clients, is the funding aspect. So not only establishing the trust and figuring out what exactly the client needs, but when it comes to signing the documents and then actually giving the true instruction on how to actually fund the trust. What should we do with our checking, savings, or trading accounts? What should we do with any retirement accounts, life insurance, any company stock option plans, any ESPP RSUs? I have interest in a privately held corporation or a privately held LLC. So those are questions and things that we need to address with our clients. So what we do is we make a list at the time that the client comes in to sign their documents, and we tell them based on asset classes what their action items are. Unfortunately, the attorneys can't go to the banks and change your accounts because there's regulations that they only want to speak to you, the client, but we always make sure the client is well informed and well educated, so that way they can go and work with these institutions to get their accounts into the trust. Once our clients leave our office, they're given action to go take care of it. We're always available if they run into any roadblocks with these institutions to contact our team. All of our paralegals are well capable of giving the instructions on how to fund the trust if there are follow-up questions. My firm also helps clients if they have real estate in California. We will actually change the deed for the client for them. So we'll draft a new deed, have the client sign it, and we'll file those deeds in the county for the client. So their real estate holdings do get funded into the trust. And then we also constantly remind our clients through emails on various cadences, reminding them about funding the trust, amending their documents, because life doesn't stay stagnant. Things change. We get older. Our bank balances go up or down. We have more children. People pass, our relationships with our nominees change, like our trustees and guardians. So things change, and you should always be amending your documents. So we always make sure that we're in the forefront in the minds of our clients, so that one, they're cognizant of when they should amend their documents and making sure that their assets are properly funded into their trust.
Awesome. Yeah, we often recommend people put all this stuff in one book for their family, so that there's one place. And mine is the left drawer of my desk. Something God forbid happened to me while I'm talking to you. My wife would know where the book is, where almost all the stuff is, where the notes are. There's probably a few things I have to update, but the lion's share would be there. Got it. And I'm always curious with the attorneys that we talk to. Perhaps you might have a story of where something went incredibly well because you did something just in the nick of time or something. And if you have a story where maybe it didn't go so well, and the consequences of that, so that it remind our listeners that taking action is always better than not.
Yeah. Typically, when things go well and go wrong, the only time that that happens is when people pass, right? Did they properly take the action steps that they were supposed to take, whether it be funding the trust, etc., right? Because really these documents give power to other people when you pass. And when that power is shifted to the other individual, now they need to have access to those assets. So With our firm, because we're so diligent about making sure our clients fund their trust properly, I would say a good 99% of the time clients have positive, what we call trust administration experiences, because there's no probate, because they've properly funded their trust. They went through all the action items they were supposed to. So it was a smooth transition for the clients' families, their beneficiaries. That small percentage of time, the issue is that the clients did not take the steps they were supposed to. They did not take the steps of getting their bank accounts into the trust. Or maybe they did initially, but after they established the trust, when they opened up new accounts in the future, or they bought new real estate, they forgot that they had the trust, that they should open those new accounts in the name of the trust. They forgot that they should buy the new property in the name of the trust. Now, those assets that weren't in the name of the trust aren't in that suitcase. They're not on that vacation to Hawaii. They're going to go through probate. And now that's where that probate problem arises. And yeah, we see that happen. We do our best to help our clients understand the importance of funding to help them avoid it, because that's the steps they're taking here. But again, it's like the patient went to the doctor, doc, I got possible heart issues, maybe high cholesterol. Just give me a pill. I don't want to do the exercise. I don't want to change my diet. Well, that's not going to work here. You have to take it all. You have to do it all.
Yeah, no, absolutely. And what would you say is your biggest challenge in helping people get guided through the whole process and set up properly?
I would say my biggest challenge as a business is honestly, it has nothing to do with estate planning, has nothing to do with our clients, has nothing to do with materials. It has to do with manpower and the job, and just finding great employees in California. I think that's probably my biggest challenge, to be very honest.
Got it. Got it. And as a small business owner myself, I'm well aware of that. And every couple of years, I have to, for one reason or another, replace my assistant and start that process all over. So I know what you mean. And it seems like, just between you, me, and the lamppost, it does seem like it's harder and harder to find really good, dedicated people at whatever level and whatever you're willing to pay them. I don't think it's so much pay anymore. It's like a lot of people just don't really want to work or really commit themselves to helping out the way they need to. So anyway, and what would you say you like best about the estate planning process and helping people? What special reward is that for you?
It's just the satisfaction of knowing that I've protected somebody's family, protected their children, preserved their legacy. I mean, legacy to me is very important. I have children. I'm a father of two daughters. I've got obviously a wife. I've got extended family members. And to me, it's very important. I employ several family members of my own. So for me, legacy is huge. And in that being a benchmark for me and my family, being able to provide that service to the general population of California, it's very fulfilling. And also getting just to hear the compliments and the satisfaction the clients feel, knowing that they've accomplished this huge task. Many people at the beginning of a new year put this on their my to accomplish for the year, or at the end of the year, they're trying to accomplish this. And once they accomplish establishing their estate plan, they're telling our staff or me, they're sending us emails and leaving reviews. They're saying how thankful they are and what a weight was lifted off of their shoulders by getting this work done.
Yeah. And like most things, it's actually easier to do it correctly upfront and correctly than it is afterwards, right? So you're actually saving yourself and your family and your assets and all the things that you would hope to happen properly are actually getting done, and it's much easier ahead of time and then updating. One final question: how often do you recommend that clients update things with you? Like, once they're all set up, is it like a 2-year, 5-year? How do you look at that?
Yeah, I would absolutely not put a 2 or 5 year deal on it. I would put it on life-changing events client in your life, right? Life-changing events could be people have passed away that you had originally nominated. Maybe one of the spouses has passed away. Maybe children have passed away. Maybe we've had additional children. You want to change the order of your trustees, guardians, healthcare agents, orders. Maybe the way things were distributed in the event you pass, instead of if you had kids equally to the children, you want to give more to one kid, less to the other, or leave some to charity. So you want to make distribution changes. Maybe there was a change in your net worth that was significant from when you established your trust to what it is today. Maybe your net worth exceeds the federal thresholds for estate tax purposes. Those would be definite instances in which you should be amending your document. So I wouldn't put it on a certain yearly cadence. I would put it on, when does your life require that? You will know when you need to get back into contact with your attorney. And when in doubt, always reach back out to the attorneys to get guidance. Hey, do I need to make changes? And then we get asked 3, 4, 5 times a day from existing clients, do I need to make changes? And then we just give them, hey, this is the checklist. Do you need to make changes based on ABC? And usually it's yes, and then we get them back in to make those changes for them.
Awesome. Sounds like you guys do an excellent job both in Northern California and down here in Southern California. So unless you have any particular thing you'd like to also share with our clients, I think that's going to do it for today. You've been an excellent guest. And I say that very truthfully. I interview a lot of attorneys and it's been really fun and enlightening to speak with you. So any final words of advice?
Well, Stephen, first of all, thank you so much for having me on the show. I truly appreciate it. And thank you for your words. And, the ending piece of advice here in my 2 cents is really at the end of the day, it's not about the bank balances, not how many commas we have at the end of our net worth. The most important asset you have are the ones that you leave behind. So this is the biggest gift you can leave behind for those. And the way to preserve and protect your legacy is to establish that estate plan. So protect the ones that you leave behind, protect your family by establishing your estate plan.
Awesome. And all of our listeners should also be reminded that at Legacy Leaders, that's what we help you do. Beyond once you've done your wills and trusts, and once you've done and obviously you usually have the assets and the income taken care of, that the Legacy Leaders is there to help you with some of those other legacy rituals and personal parts of legacy planning. So anyway, thanks for listening. This has been the Legacy Leaders podcast with your guest host, Stephen Stepp. Today, my guest was the president and founder of Singh Law Firm, Kern Singh. And again, you can contact us and we'll be able to put you in touch with them. And again, they're in Northern California and Southern California. And more importantly, they do only estate planning exclusively, which is an awesome thing in and of itself. Thanks for listening. And Kern, thanks for being with us today.
My pleasure, Stephen. It was wonderful. And thank you again.
You've been listening to the Legacy Leaders podcast with Katie Beth Hand and Stan Miller. For more information on them and the show, please visit pinnaclelegacylaw.com. If you like what you've learned today, do share the program with your friends and subscribe wherever podcasts are found.